Now, for more on what this insider trading case may mean for Wilson Sonsini and the firm's tech clientele, we're joined by Jahan Raissi, a partner at Shartsis Friese. Raissi has worked in enforcement at the SEC and has extensive knowledge of how these investigations play out. So earlier, you were chuckling at those quotes from the complaint. What's your reaction to this?
Well, this is clearly an egregious case, and it's a case where the level of intent is not unprecedented, but on the high end that you see in insider trading cases. Both the amount of money involved here is on the high end, quite a bit of money involved, but also the level of intentionality, the steps that these folks allegedly went to hide their tracks and to continue this scheme for well over a decade. It's really an important case that's been brought here, and one that in many ways reads like a movie of the week. The allegations of prepaid cell phones to avoid telephone records, small denominations of cash to avoid bank transfers, potentially burning cash to avoid fingerprints, meeting in Atlantic City to make cash transfers appear as though they were from the proceeds of gambling. Entertaining, amusing, but quite serious stuff in the criminal complaint here.
Now, what's mind-boggling is that he had access to this information on deals he wasn't even working on. He had access to it, and he also shared it. I mean, is that standard practice inside law firms to easily get that kind of info?
Sure. I mean, a law firm, by its nature, has a lot of confidential information. Some of the most important duties that lawyers have are duties of confidentiality to their clients. That's not uncommon at all. The uncommon part of it, and the egregious part, is sharing that confidential client information with others, and especially with others to profit personally.
I want to read you a quote from Carl Sanchez, head of M&A for Paul Hastings, a big competitor to Wilson Sonsini. He says, Wilson Sonsini is a sophisticated firm. I've worked with them, opposite them on many deals. In my communications with them, they follow the same procedures we follow, assigning code names to clients, not revealing them until the very last minute. That's M&A Deal Security 101. So what went wrong here?
Well, we don't know for sure. I mean, Wilson Sonsini is a top-shelf firm. They do things right, and I'm sure they have all the standard protections in place. But remember, law firms are in the business of creating legal documents for their clients. Those legal documents have to have the identities, the names of the companies involved in transactions. They'll have press releases. They'll have board minutes and other documents that have to have the names of the companies involved. So it's not possible at a law firm to both do the job the law firm needs to do and have perfect security.
Could this damage Wilson Sonsini's sparkling reputation?
Well, I don't think any firm or company would want to have their name in any way associated with insider trading like this. And so it certainly is a bit of a black eye, nothing, again, that they would want to have anything to do with. On the other hand, I think most sophisticated people understand that if you have an employee that allegedly is going to go to these ends to find confidential information and profit on it surreptitiously, there's not a lot a law firm can do and still do what it needs to do for its clients.
Is there any concern this could become a wider pattern within the industry if lawyers have access to this information, or is this guy just an isolated, alleged crook?
Unfortunately for my profession, no, it's not isolated. There have been any number of cases where lawyers have breached their duties to the clients, traded on the information, provided their friends with the information. I don't know that this is necessarily the start of something new, but it's been happening. It will continue to happen. I think what's interesting and new here is that the government was able to get behind a fairly well thought out scheme to cover their tracks and hide the trading here. And these guys had something that allegedly looks like they had given quite a bit of thought into avoiding detection, and it didn't work for them.
Now, technology companies have been involved in a number of these insider trading scandals in recent months. Is there something about technology companies or long tech supply chains that make them more vulnerable to these kinds of things?
Well, I think as an industry, technology companies generally engage in more corporate transactions, and their trading tends to be more focused on M&A activity as well as earnings announcements. And so there's more opportunity in the technology industry for insider trading. In addition, the technology industry, by its very nature, is a little more open with information. More people know about more things before the events happen publicly, so there's more opportunity for insider trading.
So how do you see this playing out?
Well, in this particular case, assuming that these allegations are close to the truth, I don't see that there's too much room to maneuver here. And at least based on these allegations, it looks like that the defendants here will be doing a considerable amount of time.
And CC1, the unidentified middleman, I mean, do you think he's working with the feds? Obviously, these calls were wiretapped.
Right. I don't know for sure, but given the fact that he's not been charged in either the criminal complaint or the SEC's complaint, the nature, as you point out, of the telephone recordings, where they have recordings of disposable cell phones, which are very difficult, if not impossible, to otherwise tap, I think it's a certainty that he's cooperating with the government, and the real question for me is whether he's been granted immunity, which means they won't go after him, or they're going to go after him, but he's going to have a reduced sentence because of his cooperation.
All right, Jahan Raissi, fascinating insights about a fascinating case. Great to have you here on Bloomberg West. Thank you.